The following program is made possible in part by the Dayton Bar Association.
Good evening and welcome to You and the Law. I'm Mike Monta, your producer and host for tonight's program. And the topic for tonight, a very interesting one, just been through the Supreme Court. You've heard a lot about it in the media, and we're going to be talking about same-sex marriage issues. Joining me as guests on tonight are two renowned experts in our area. Judge Stephen K. Dankof of the Montgomery County Common Pleas Court. He's the judge there. And Professor Richard Saphire from the University of Dayton Law School. And they'll be fielding your questions if you call in, or fielding my questions if you don't. So before we get to our discussion, let me remind you that You and the Law is a monthly presentation produced here at the studios of the Dayton Access Television. DATV is on Channel 5. It's the public access channel of Time Warner Cable Network here in Dayton. The program's also cable cast on tape delay through the auspices of the Miami Valley Cable Council. We also stream to you live at DATV.org. So if you're not getting us on TV, turn on your computer and get DATV.org, and you can watch along with us. It's an audience participation program. You can see the number on the TV right now. It's 223-5311. We have operators to take your calls and bring them to us. So let me introduce our guests, or let them introduce you to you more fully. Tell you a little bit about their backgrounds and familiarity with today's topic. So much for the intros. We'll turn to Judge Steve Dankof, and good evening. Nice to have you on the program.
Well, good evening. Nice to be with you in some format other than on the golf course. A little background, very little. Graduated Oakwood High School, 1969, Ohio University, 1973, University of Texas School of Law, 1976. Came to Dayton because my wife told me to, and went to work for a firm called Smith & Schnocky, where I was a partner until 1989, and then I was essentially a solo practitioner for the balance of my so-called career. And then at the end of December 2010, the governor appointed me to the Common Pleas bench, and I was reelected to that position by the voters last November. So that's a little bit of my
Judge
background.
Dankof, great to have you here. And we'll turn now to Professor Saphire. Good evening. Nice to have you on the show.
Nice to be here. I'm Richard Saphire. I have been teaching at the University of Dayton School of Law for, this will be my 37th year. During most of that time, I specialized in constitutional law, and I've also been a civil liberties lawyer, so I've been litigating civil liberties issues in the courts for probably over 3 decades. This semester I'm teaching a course in constitutional law, and my law students and I just finished a class where we spent the entire time talking about just the issues that we're going to be talking about this evening.
Excellent. Well, recently, in the last week, you may have seen that the Supreme Court of the United States took 2 cases, one which was called Proposition 8 from California, which is determinative of, well, it may be determinative, and we'll discuss that, of whether same-sex marriage is legal, and a second case which relates to the Defense of Marriage Act, which was signed by Mr. Clinton, who was our president back in 1996, and indicating that a marriage is one man and one woman. And we're litigating that to see if other people can get married of same gender, and whether this is a constitutional problem. So, with that in mind, maybe a little background on how we got here on the issues.
Well, some other people can get married even if they're the same gender. If they're fortunate enough, at least from their point of view, to live in 8 or 9 states that currently recognize gay marriage. If they live in a state like Ohio, and most of the other states, however, they're not fortunate enough to get married if they want to, because Ohio, by virtue of an amendment to our state constitution that the people added in 2004, prohibits gay marriage. So, to a significant extent, where you live will determine whether or not you're free to marry somebody of your choice, including somebody who is of your same gender. The Defense of Marriage Act, one of the issues before the Supreme Court last week, reflects a federal law, as you said, that was enacted in 1996, and that act prohibits the federal government from recognizing same-sex marriage, even in those states which have come to recognize it through their own law.
The people who believe that the Defense of Marriage Act should stay in place, is this coming from a moral aspect less than an equal protection type thing? 14th Amendment, I think, allows equal protection for all of its citizens. And there's lots of things that if you were married, you would have federal rights as well as probably states' rights. Any thoughts?
I have some thoughts which I'll share, and then
let's hear them.
Perhaps that might prompt something from Professor Saphire. I don't think there is any doubt that this whole issue is a political issue. It's got political underpinnings to it. I was looking at some statistics today. This is an issue that has, as we might say, flipped dramatically within the last several years. If you went back and looked at polling, the significant majority of Americans within a relatively short period of time ago would have opposed gay marriage. Presently, 53% of those polled, the American public, is now in favor of gay marriage. 68% of Americans under 30 favor gay marriage. 65% of Americans in their 30s favor gay marriage. So the fact of the matter is, the issue really and truly is decided. And by that I mean when...
socially.
Yes, when my mother's generation dies out, and certainly by the time my generation dies out, this isn't going to be a topic for you and the law. This will be long ago decided. The Supreme Court, if it doesn't do it now, will do it at some point in the future. And as Professor Saphire and I were discussing before we came on the air, at least I liken this, and he may have a different view, and he's certainly far more knowledgeable than I about constitutional law, but I liken this to the slavery question. You know, in 1857, we had the Dred Scott decision, which was intended by I think it was Chief Justice Taney, if I've pronounced his name properly, perhaps Taney, who wrote a decision that he thought was going to settle the question and avert civil war, and it had the exact opposite effect. Then a short 40 years later, in Plessy versus Ferguson, the Supreme Court decided that, and this was after the passage of the 13th and 14th Amendments, the 13th Amendment outlawing slavery, as anybody who knows that recently saw the movie Lincoln, and then the 14th Amendment regarding due process. So a scant 39 years later, We have Plessy versus Ferguson that says separate but equal is the law of the land. Segregation is all right as long as you provide equal accommodations in public services. And then a scant 58 years later in Brown versus Board of Education, we get a completely different result with Chief Justice Warren. So this is a political issue akin to slavery and the treatment of race in America. It's no different. I would suggest that if we want to go back to the Old Testament, for example, and moral underpinnings for slavery, the Old Testament seemed to support the institution, and no one in his right mind today would argue that that's a tenable position. So ultimately, this issue will be decided politically, and in fact, you can look at what's been discussed this week and the arguments that the justices have heard and the questions that they've asked the litigants, and they have openly, they being the justices, have openly questioned whether they should have granted cert in these cases in the first place, and even heard them because perhaps the time isn't right. And so they sense the political winds are blowing themselves, and as I say, the Supreme Court, like it or not, is an overtly political body, and so this is a political question, and it will be treated as such.
Let me ask this. And of course, our knowledge, a lot of it about the 14th Amendment comes from the recent movie about Lincoln, and Lincoln wanted to pass the 14th Amendment so it wouldn't go state by state.
I think the 13th Amendment is 13th. The issue that was up for grabs.
Well, we'll get to the 14th here. And is that not similar to the question that we have with the Supreme Court now, whether they say, you know, we're going to send this back to the states, or we're going to decide it now so you'll get equal protection for your marriage from one state into the next?
Well, if you don't mind, can I ask another question you asked?
Absolutely.
You answer another question you asked before this one. You asked the question of whether or not the whole issue of gay marriage is a moral issue. And the judge responded by saying that he thought it was a political issue, and I agree with that, but also a moral issue. And I think that's a really important question. One of the reasons it's important from a legal point of view is that the Supreme Court has in recent cases said that a state can't enact a law which hurts or disadvantages a group of people simply just because the state morally disapproves of who they are, morally disapproves of those people.
Justice Scalia seems to think there might be moral authority to uphold the law.
Well, maybe we can talk about different ways of thinking about the Constitution, and that's consistent with Justice Scalia's overall view of the Constitution. But the reason I raise that is because if you look at what happened in the lower courts, and some of this came out in the Supreme Court's arguments last week as well, but the states that have tried to defend their bars or their prohibitions on gay marriage, and the federal government, at least the House of Representatives that's defending the Defense of Marriage Act, the Obama administration is not defending the Defense of Marriage Act. But
they withdrew, didn't they?
They withdrew. So there's a group of congressmen from the House of Representatives who is essentially trying to defend the act. Those folks who have been trying to defend those statutes, or like in Ohio, a constitutional provision that prohibits same-sex marriage, are sort of bending over backwards trying to argue that in fact these laws are not enacted for moral purposes. They're trying to argue that there are non-moral reasons for these laws. The problem is that each of the arguments that they make tends to kind of dissolve when it's closely analyzed. And I thought that one of the telling points during the oral arguments this last week was when one of the justices read to the lawyer representing the federal government a provision or a section from the House of Representatives report, legislative history, the conference report in 1996 when the House enacted DOMA. And I have the language here, but the passage made it as clear as it can be that those people who were supporting the Defense of Marriage Act We're supporting it because of their moral disapproval of gays and because of their moral disapproval of the notion that gays should have the same rights to marry as heterosexuals have the right to marry. So at the end of the day, I think if the Supreme Court strikes down one or both of these laws, I think a lot of the reason for doing that is the conclusion that there's just no other plausible explanation for these laws today than simply a majority of people in a particular state simply morally disapproving of homosexuals.
When Judge Dankof was talking about this being a political issue, doesn't the Supreme Court is there for life, and whatever they decide, unless we have a change in that, is it not likely that they may not catch up with what the rest of the country feels ought to be done for a while? What do you think?
Is it not likely?
I mean, if the Supreme Court either says, you know, we're really not going to decide these issues on a broad base, or we're going to decide in favor of the Defense of Marriage Act, which would be opposite of what the climate seems to be today. That
Right.
still remains the law, despite what the climate is.
Right. What's your question?
The question is, what should the rest of the country do? I suppose they can go state by state from there.
Well, I think the problem is just the opposite of the problem that you've identified. I think that one of the reasons why some of the justices expressed some concern about whether they really should have taken these two cases in the first place, and perhaps even reconsider whether they should take the cases, is not because they lag behind popular opinion, because they don't want to be ahead of popular opinion. And as a result, the court, I think some justices are looking at what's going on the states, just as we did, and are seeing that there's a lot of change in people's thinking. There's a lot of evolution of the moral views that people have on this issue. And I think that the judges sense, just like many of us do, that if they wait long enough, sort of like capital punishment, if they wait long enough, most states are going to change their views. Now, you can take a state, for example, like Mississippi, where one would imagine it's terribly unlikely in my lifetime to see popular opinion swing dramatically enough to change attitudes of folks down there. But you can take a lot of other states where they're sort of blue and green states, states where you have a lot of diversity of political opinion, a lot of diversity of population. And I think it's probably true that in many of those states, that things will be moving in the next 8 or 10 years. And I think the Supreme Court would prefer, if there's going to be change in public policy on this issue, I think the Supreme Court would prefer that change take place through the political process and not take place as a result of Supreme Court decisions.
Let me take the flip side of that argument.
Please.
There is some speculation, and it's speculation, because it's never really, the public is really never informed as to who the votes were to take the case for review. But there's rampant speculation that's been published in the New York Times and elsewhere that it is in fact the conservatives on the court, headed by Justice Scalia, who has some rather interesting views about the Constitution.
He's an originalist.
He is whatever suits his particular purpose.
He says he's an originalist.
He, you know, if he's an originalist and he's a states' rightser, as he purports to be, then what was he doing in Bush v. Gore? So the point is this: there's an indication that the conservatives on the court decided they would take the case now, because if they can't stop the march toward equal protection and gay marriage now, they'll never stop it. They think they have the votes on the court, and so they've acted now at a time when they think they can plug the dike, and they're proceeding accordingly. That's one point of view. And which one of those it is, I don't hazard a guess. I simply will say that, as I said earlier, time is not on the side of those that oppose gay marriage.
And I agree with that. One of the things that was so remarkable about the Supreme Court taking, especially the case from California, because many people who observed the Supreme Court were really very surprised that the Supreme Court took that case. And the primary reason for that is that the outcome of the decision in that case had an effect on only one state in the Union, and that was California. And so had the Supreme Court not taken the case, the decision of the Federal Court of Appeals, which struck down California's very special policy against gay marriage, would have stood, but it probably wouldn't have had much effect outside of California. So people were really trying to struggle to figure out why the Supreme Court was interested in taking that case. And Judge Dankof's interpretation, I think, is probably the best interpretation of why the court said, even though we're pretty confident that that decision can be confined to the state of California, we're going to strike when we think the iron is hot, or at least as hot as it's ever going to get. Now, the problem with that equation is that the fifth vote on the Supreme Court, it takes 5 votes to reach a decision by the Supreme Court. The fifth vote on the Supreme Court is Justice Anthony Kennedy. And Anthony Kennedy has written 2 of the court's most recent opinions that have been favorable towards gays and lesbians, towards the idea of homosexual rights. So most or many observers believe that Justice Kennedy actually may represent the 5th vote for striking down bans on gay marriage, and not the other way around.
Do you think that maybe the Supreme Court took these cases in tandem, the California case dovetailing in, because it's primarily about same-sex marriage? That's the issue, whereas the Windsor case in New York, the Defense of Marriage Act, seems to have more emphasis on benefits of a marital partner.
Well, number one, I don't think we'll ever know until maybe after the current justices die, because the Supreme Court is a very private and secretive institution. And even though presumably the justices tell each other why they're making these decisions and why they decide to take a case or not to take a case, usually that information doesn't get to the public until after the justices die or retire from the bench. Having said that, I think that the Defense of Marriage Act case is an especially interesting case because it doesn't just raise the question of homosexual rights. It doesn't just raise the question of whether your states that refuse to recognize gay marriages are discriminating against gays in an unconstitutional way. It also raises a very important question about who has what power in our system, whether the federal government has the power to do various things or whether the states have the power. And it's long been the view, expressed by the Supreme Court many, many times, that the primary place for making decisions about marriage and domestic relations issues is not at the federal level, it's at the state level. And so a lot of people view the federal law that says that we're not going to recognize any benefits associated with gay marriage, even in those states where the states recognize those marriages. A lot of people think that that's an intrusion onto the rights of the states.
But to get equal protection for the whole country, you're going to have to say you can get married in every state, aren't you?
One would think that if the court...
I mean, that's a simple way to put it.
Well, but I mean, there's more than one way to skin that cat, as it were.
Okay.
That is, the Supreme Court could strike down the Defense of Marriage Act by claiming that the federal government's action essentially approving heterosexual marriage but disapproving gay marriage violates the equal protection provision of the Fifth Amendment to the Constitution. But it's possible that members of the court could even dodge that question and simply say that this is not a constitutional exercise of Congress's power because it steps over the rights or the prerogatives of the states.
Okay, we're going to take a very short break. We're 25 minutes into the program. I want to let you know that we are sponsored by the Dayton Bar Association. If I didn't say that at the beginning of the program, I'm saying it now. Proudly serving our community and legal profession since 1883, which is before any of us started practicing. And they serve our brethren as well as the community. Have several important programs. Wills for Heroes is one of them, and that is where volunteer members of our association create wills for emergency first responders, firefighters, police, EMTs. If you want to avail yourself of that program, call the Bar Association, 222-7902, I believe. There's a lawyer referral service. If you don't have a lawyer and nobody to refer you one, call 222-6102. If you want to become a notary, they can do that also. Bill Wheeler's the director over there and been doing a fine job for, how long's Bill been here? 10 years or so?
I'd say at least.
Yeah. He's here so long, we can't remember anybody before him.
Well, that's because we're old, Michael.
Well, I guess. Are we in, Judge Dankof, are we in the age group that should be against this same-sex marriage? Are we in that graphic?
Well, I think the answer is that.
And you don't have to actually.
Should we be?
Should we be, right?
Well, I don't know how to respond to that. I would say the demographic represented by someone of at least my advanced years. Okay. I won't speak about yours or the professors, but I suspect that my demographic, which is I'm 61, I suspect that my age group is probably, although it's gotten closer, I think it probably is still on balance opposed to same-sex marriage, narrowly would be my guess.
Let me add.
And by the way, I mean, I think
I thought you were going to give your age there
well,
for a second.
I'm 67, so I'm in a different cohort. But you know, I think there's also an important religious dimension to this issue. And
well, that's what I was alluding to, I think, before when I said moral. But yeah, go ahead.
Well, but I mean, there's religious morality, and there's arguably non-religious based morality as well. But I mean, I think that what is it right now? 25 or 30% of the American public is Roman Catholic, and it's still the position of the official position of the Roman Catholic Church to disapprove of gay marriage. That's true with respect to some other religious organizations as well. For example, many Orthodox Jews oppose gay marriage. Many evangelical Christians oppose gay marriage. I think many very observant Muslims oppose gay marriage. And I think that to a significant extent, that's a vestige of that's a vestige of a religious moral teaching and moral training that was traditional. But I think the opinion polls show that fewer people today, younger people, whether they're Catholic or Jewish or Muslim, regardless of what their religious connection or their religious affiliation, fewer people today tend to accept or tend to act on the basis of a lot of moral teachings of their religious communities. And I think to some extent you're seeing that as well, because if you look at those same opinion polls that the judge referred to, even among younger Catholics, for example, there's strong and growing support for gay marriage. My guess is that if you looked at the older generation of Catholics, 65 and older, it's probably just the opposite.
I agree with that.
Okay, let me just tell you, the viewing audience, if you don't know, you are watching You and the Law. There's a great big sign right behind us there. So we are talking about same-sex marriage. The phone number's right there, 223-531-5311. We're streaming live at DATV.org. If you're watching this program live right now, and it's April 1st, no joke, you should be calling in, because I know that there are opinions out there or questions about this that we can talk about it, but we don't know what you're thinking and what you want to know. So please call in, and I'm looking at, wait a second, we may actually have a call. Okay, we'll get to that. We'll get to that in a minute. And we'll break into whatever we're saying. Yes, there is a call on line 1. So, good evening. You're on You and the Law, and please tell us your question.
Hello?
Hello.
Oh, can I ask my question now?
Yes.
Okay. My question is, Professor Saphire, you sort of touched on the potential outcome if DOMA gets struck down, what that will mean in a legal way and to gay marriage. But I'm wondering if you could maybe sort of break it down at its simplest level. If the decision goes this way, that's what it's going to mean for the gay and lesbian community, or if it goes this way, that's what it's going to mean.
Okay, let me try. If the Supreme Court strikes down DOMA, the Defense of Marriage Act, that doesn't mean that anybody who can't lawfully get married, any same-sex couple who can't lawfully get married in the United States is going to be able to do it. That is, the Supreme Court's decision is not going to affect the substance of state laws like Ohio, where Ohio prohibits same-sex marriage. What it will do is it will say in those states where gay marriages are permitted or where they're recognized, in those states, individuals are entitled, gay and lesbian couples are entitled to all of the benefits, if they're married, that heterosexuals would be entitled to. And that includes just everything from Social Security to disability to laws that have to deal with what happens when somebody dies and how the estates are distributed and so forth. So I think it's important to note that if the court strikes down the Defense of Marriage Act, it doesn't mean that if you live in Ohio, you're suddenly going to be able to get married if you're gay or lesbian. You won't. That's going to result, hopefully, that might happen if the Supreme Court strikes down the California Proposition 8. That might have consequences for states like Ohio. If the Supreme Court upholds DOMA and says that it's constitutional, then until Congress makes the decision to repeal the statute, we're going to continue with a system where we have a dual system, where if you are heterosexual and you're married, you're entitled to all the benefits associated with federal law, but if you're homosexual, whether you're married or not, you're entitled to none of the benefits associated with federal law. Does that help?
Thank you.
Okay. Let me follow up on that. And the specific question in the Windsor case is, I think for Mrs. Windsor, or Ms. Windsor at least, whether she gets her $360,000 back. So if the Supreme Court did strike down that act, ostensibly saying they were going to recognize the marriage from Canada, will that narrow the issue, do you think?
No, it'll mean that gays and lesbians, like Ms. Windsor and her former partner, had she still been alive, would be entitled to all the recognition, all the legal benefits that any other married couple would be entitled to.
If they're legally married in some jurisdiction.
If they're legally married in some jurisdiction, right? They could be legally married. Theoretically, they could be legally married in a state that recognizes marriage. They could move to a state that doesn't, but because of its own law, the state is willing to recognize, the state itself is willing to recognize benefits that accrue to married couples. And even in that situation, those individuals might be eligible to receive federal benefits. But we're talking about federal benefits, benefits in federal law, not benefits that are associated with state law.
Okay, in the individual states, then they would have to recognize same-sex marriage.
Right, and that's an important decision, because if the Supreme Court, the judge was saying it's possible, it's not likely, but if it's possible, the Supreme Court said, we really shouldn't have granted review in this California case, and we're going to send the case back down to California and let the lower decision stand. If the court does that, but nonetheless says that the DOMA statute is unconstitutional, that's not going to change any state's law that now prohibits or permits gay marriage. That's going to be still left up to the states to make to decide.
If they decided for the litigants in the Prop 8 case, which, as you said, is unique to California, does the Supreme Court then have any jurisdiction, do you think, to expand that nationwide, regardless of what happens in the DOMA case?
Well,
they'd probably connect them at that point.
It would all depend on how the Supreme Court decides the case. Usually the Supreme Court prefers to decide cases on a narrow ground as opposed to a broad sweeping ground. I mean, a counterexample of that is Roe against Wade. In 1973, the Supreme Court said that the Constitution guarantees a right for women to have an abortion. The way the court decided that case, it had national implications. It applied across the country. In Brown against Board of Education in 1954, when the Supreme Court said racially segregated schools are unconstitutional, that applied throughout the country. It's possible for the Supreme Court to decide the California case in a way that only has effect in California. It's also possible for the Supreme Court, I don't think this is going to happen, but it's also possible for the Supreme Court to write a very broad opinion which would essentially say that no state can discriminate against gays and lesbians with respect to marriage. And if that's true, then the effect would be in Ohio and other states that now prohibit gay marriage, that those laws would ultimately fall.
Let me just say, and I agree with what Professor Saphire just indicated about, if you're a betting man, what the likely outcome is going to be given the makeup of this particular court.
Yeah,
all I'm saying is sooner or later, and perhaps it'll be sooner, but probably more likely than not later, there will come a day when the court will issue a decision, because the political winds will dictate that decision at that point in time, where they will issue a sweeping decision that says no more prohibition against gay marriage. That will happen. It's just a question.
But you have to remember, you referred to this case at, well, if you didn't, I will. In 1967, the Supreme Court decided a case called Loving against Virginia. And in Loving against Virginia, the question was whether or not states could prevent blacks and whites from marrying each other, interracial marriage. And the Supreme Court finally said that the answer to that question is no, they couldn't. But there was 13 or 14 years between the Brown against Board of Education decision and that decision.
Right.
And many states had not changed their policy. So it may be the case, but if the Supreme Court doesn't resolve this issue at the constitutional level, as I said, we're still going to have a patchwork, I think.
Oh, sure.
There are going to be some states that are amenable, that now prohibit gay marriage, that are going to be amenable to rethinking the question, maybe even Ohio. But there are some states, and let me just pick a couple at the top of my head, Idaho, Mississippi, and Alabama, where I would be amazed if during our lifetimes there's going to be enough movement on this issue in the political arena for those states to change their policies.
I agree with the professor wholeheartedly, particularly on the three states that he picked. There could be others. But the fact remains that just ask yourself, flip the question another way. I mean, but for Brown and but for the case that said we're not going to have any more laws prohibiting, what's the term, miscegenation?
Yeah, miscegenation.
Does anybody think for a second, if the Supreme Court hadn't acted on a nationwide basis, that our friends in many of the states south of the Mason-Dixon would still they'd still have those same laws. It would still be illegal, and there's just no question about that. So there comes a time when the court feels that it has to act because the political situation is such that it must. I don't know that we're there yet, but there will be a day, and it may not. Again, you're right. It may not be in our lifetimes, but it'll certainly be in the lifetimes of my children.
Okay. Let me take another call, and we'll get back to that. Good evening. You're on You and the Law. What is your question?
Hi. My question actually concerns a provision of DOMA, which I don't think was before the court last week. But my understanding is that there's a provision of DOMA that says basically that states who don't have gay marriage don't have to recognize the marriages from other states where they do have gay marriage. And I'm just wondering if the panelists can speak to the status of that provision. I know it's been challenged in the courts as potentially conflicting with a constitutional provision that says that states have to give full faith and credit to the laws of other states. But I'm wondering what the status of that is, and really if there are any good arguments for upholding that provision, and if that's going to come before the Supreme Court anytime soon.
I'm going to defer, and this may be entirely unfair, I suspect not, however. I'm going to defer to the professor on that one.
Okay.
Well, it's 50% not. You're right that there is a provision of the Constitution that requires states to give what's called full faith and credit to the policy decisions and the laws of other states. There are also some exceptions to that. And for example, where there's an important question of public policy at issue, some states are permitted in exceptions. I think at the end of the day, what would happen is that if the Supreme Court strikes down the DOMA provision, by implication, although the other section of the statute that you referred to is not challenged in this case, that other section of the statute is likely to fall as well, because I suspect that if the court strikes down DOMA, it's not just going to be because the court disapproves or says the Constitution disapproves of the discrimination against gay and lesbian couples. I think it's also going to be because the court's going to say that Congress really doesn't have any business in telling the states what they have to do and what they can't do with respect to marriage. And if that happens, I think the principle of what's called federalism principle that applies to DOMA would also apply to any federal policy which tries to exempt states from having to give full faith and credit to the laws of other states in this area. Does that help?
Yes, thank you very much.
You're welcome.
Okay, thank you, caller. One thing that, you know, at the beginning of the program, we talked about the blazing speed this issue has taken over the course of the past few decades, and as early as the 70s, homosexuality was considered a mental disease. Sodomy laws, I think, were just struck down, within the past 10 years, finally.
They were originally upheld by the Supreme Court in 1986, and the Supreme Court reversed itself on that about 9 years ago.
Yeah, and I shouldn't say when I'm supposed to be working, I'm watching Dr. Phil, but they had this issue on about a young lady whose mother didn't want her to have a lesbian relationship. She says, that's who I am, and Dr. Phil, who may have been in that section in the 70s saying it's a mental disease and we're going to try and get you help, which is what Dr. Phil usually does, is on the side now, obviously, even though he is in his 60s and of that old generation that Judge Dankof talked about. Trying to bring this into the 21st century. Do you think it's because of more educated people in this issue that is spurring the demographic to move forward? That's a long-winded question.
Well, I think there's a lot of truth to that. I think that it's like almost any other issue. I think it was part of the Supreme Court's philosophy or principle in Brown against Board of Education when the court said that segregated schools were unconstitutional. I think that the notion is that when people learn about other people, when people learn that there are other folks out there who may not be the same as them or think the same as them or live the same as them, but actually learn that they're living, breathing human beings who have the same desires and the same wishes and the same expectations out of life as others, their attitude tends to change towards them. And so I think what happened back in the 60s and the 70s and the 80s is that homosexuality became less closeted. That is, homosexuals began to come, as the term was back then, came out of the closet. And as a result, people began to realize that members of their family, people with whom they were, people with whom in neighborhoods in which they lived, were homosexuals, and those folks actually weren't so much different than we are. Those folks really aren't as bad as I've been told that they were. And as a result, and I think that's especially true of this generation, more and more and more homosexuals, gays and lesbians have become proud about their identity, have been willing to come out and disclose to family members and others who they are. And when heterosexuals find out that they're really just like us, they have the same problems and the same expectations and the same hopes out of life, the same expectations for relationships that we have, I think your attitude tends to change. And that's just snowballed over the last 10 or 15 years, and a lot of it is because homosexuals took the brave step of coming out and revealing to those around them who they were and what they were.
Let me give you a little anecdote maybe. I used to teach a class, did for 17 years. I taught a class at Antioch's McGregor School in their MBA program. And what I taught was a legal survey class, which was essentially just a broad brush of the lawyers and the legal profession, and basically for people that wanted to be MBAs, how to interface with their lawyers, both outside counsel, in-house counsel, and so on and so forth. One of the topics that I would give them to write about in that class was I would ask them to read a letter from a Birmingham jail. It was written by Dr. King in April 1963, and one of the most powerful pieces of literature I think ever written. I was frankly amazed that I had never been exposed to that piece of literature until I took a course from Professor Tilmain at the UC Law School called the Justice Institute, and I thought my academic background was rather woeful since I didn't know about the letter until I was probably 50 years of age. But in any event, the letter is quite remarkable and talks about concepts of justice, and I think it was Dr. King that opined that anything that advances the human personality is by definition justice. In any event, I asked my students to write a paper on whether or not if Dr. King were alive today, would he be an advocate for or against gay marriage? The simple answer is, well, Dr. King was a Baptist minister, ergo he must have been opposed and would have been opposed to gay marriage. A little more nuanced answer was that one of his very close friends, I think, was Bernard Reston, who was openly gay and who was one of Dr. King's closest confidants and advisors. And within Dr. King's own family, that is to say his wife, Coretta Scott King, and his daughter, his wife believes he would have opposed gay marriage. His daughter believes he would have supported it. And so what we see, as Professor Saphire has already talked about, is, you know, again, because more and more gay people are coming out, as the saying goes, it's less and less remarkable in this day and age. More of us know people that are openly gay, proud of it. Witness only, what was it, 2 weeks ago? That Rob Portman, our own senator from Ohio, who could hardly be called a bastion of liberal thought, came out and said, hey, you know what, I've been rethinking this issue. And why was he rethinking it? Because his son had the courage to tell his parents that this is who I am. It forced Senator Portman to rethink it, much as Dick Cheney, hardly a liberal by anybody's stretch of the imagination, rethought his position because of his own daughter. So more and more people rethink the issue every day because it is less and less in the shadows. It's more in the open, and so I don't think there's any question that the professor's right.
But you know, it's not to say that there's unanimity. I mean, I recall it wasn't too many years ago when the Dayton City Commission was considering an ordinance to prohibit discrimination in the city against gays and lesbians. And one of the strongest opponents of that measure was the what do they call it, the Intercity Ministerial Alliance. I mean, largely a group of African American churches and African American religious leaders. Now, I don't know whether they would take the same position today. That was maybe 10 years ago. But so there still is strong feeling, you know, in various communities around the country that makes this issue still a very, very difficult issue for people.
And I think that was evident by the amount of people that were around the Supreme Court who probably wouldn't have cared about any other case in the world except for this one.
The only thing that we can get unanimity on, two things: free money, maybe, and that Dr. Phil needs help. So we're never.
I've never brought Dr. Phil into this program, but I thought it was was apt that, and I believe he was a psychologist 40 years ago, and he probably was on that side. One of the things I thought was interesting was when we're talking about tolerance, and there's a couple of things I wanted to ask. In the mid-'80s, we had the AIDS epidemic, which a lot of people who were against same-sex relationships felt as though would maybe end any progression of that, but it really hasn't put a dent in it at all. And secondly, and Judge Dankof indicated before that people under 35 now are, it seems like tolerance isn't even a word that would apply. It's almost like indifferent that there is an issue. Reminding me of the old South Pacific song where they say you've got to be carefully taught. I am right on that, aren't I? And yet
wow,
this
South Pacific.
This generation now who feels indifferent to the issue wasn't taught. After years and years of hatred, prejudice, why now? Is it the internet, or
well,
that it is geometrically exploded toward being okay?
Well, I think, you know, the internet has, if nothing else, has given a lot of us access to material that we otherwise wouldn't have had access to, such as my ability before I came on the program tonight to Google current public opinion polls on the subject of gay marriage, so I at least had some relatively new data to spout to sound like I had some idea what I was
You'd have had to go to the law library.
Yeah, and anybody that knew me as a lawyer would know that I would eschew that opportunity at every chance I could get. But you know, the fact of the matter is that opinions are changing. They are changing rapidly, and there's just no. I mean, we can all talk about why and what are the reasons. It's a reality, and we just have to. And I would say one other thing, and I think Professor Saphire talked about this. Talked about the religious underpinning of some of the opposition and so forth being of a religious origin. And you know, the single fastest growing group in the United States as it relates to religious affiliation are those who are religiously unaffiliated. Mm-hmm. There's no question it's the most rapidly growing group.
Well,
what's that tell you?
It just doesn't make any. A lot of this. I know we have a new pope, and he's wonderful, helping the poor, and maybe he's going to divest the church of its riches to do that. But don't. I'm going to say don't call him. We only have a couple of minutes. Some of this stuff just doesn't make any sense. I mean, if people can't love one another and be free from everybody else bugging them, that seems to be what this demographic is saying.
Well, you know, Americans like to say that they value their privacy. Oftentimes, though, they value their own privacy and don't place much value on the privacy of others.
Yeah, it's great for me, but not for you.
Exactly. You referred to the AIDS epidemic in the 70s and maybe even beyond that. It's still not. It's obviously there's still a serious problem around the world, not just in the United States. But you know, there's sort of an irony for folks who oppose gay marriage. It seems to me. Back then, the notion was that homosexual was bad. Why? Because every homosexual was promiscuous, and as a result, there was this plague that was infecting through the gay community. There were even people that were saying that this was God's condemnation of homosexuals. Mm-hmm. Right?
Same people that said 9/11 was God's condemnation.
But my point is that at that time there were people who condemned the homosexual community for not wanting precisely what it is that they want now, which is to say, now what they want is they want the ability to have lifelong commitments that are sanctioned and recognized by law. They want to be able to live with the same partner for their entire lives, to say that they're married to the same partner for their entire lives, to get the same respect and the same entitlements. And so it's very difficult, it seems to me, for folks who 25 or 30 years ago were bashing the gay community because of its promiscuity to now not at least understand the humanity or not understand the compelling moral nature of their argument. And their argument, to some extent, is they want the same thing that you folks have. They want the same commitments, they want the same kind of relationship, they want the same kind of respect for their privacy decisions that everybody else has.
Okay, we've got, my floor director will tell me how much time we've got. Not very much. We're running out of show. What's going to happen? Is it going to happen? Do you think legally predict that we're striking those down and moving on really into the 21st century, or going to stay?
I learned a long time ago as a professor of constitutional law not to predict what the Supreme Court is going to do, but having said that, I think that it's more likely than not that the court will strike down the Defense of Marriage Act. I think it's likely to be a 5-4 decision.
Okay, folks, you've heard it here first.
And
if you're wrong, they'll just forget
I do not have a
said.
clue
Yeah.
what the court's going to do in the California case. And I don't think anybody else does either except those 9 justices.
Okay. Judge Dankof, any? I've got 30 seconds here.
I think talking about Prop 8 and the California deal, given the fact that Justice Kennedy is the swing vote, is from the great state of California, I think he would like very much to get away from that decision as quickly as he can, so maybe they'll send it back to the state.
I'm going to cut you off. One of the few times I can do that, probably. Thanks for watching, everybody. You've been watching You and the Law here on DATV. We've had some great guests here tonight. Judge Stephen Dankof of the Common Pleas Court, Professor Richard Saphire from the University of Dayton Law School in Con Law. It's been fantastic having you. We thank all the volunteers behind the scenes who have made our program possible. Give some thought to these issues. Love one another. I've been your producer and host. I'm Mike Monta. Thanks for watching. Tune in again. Good night and good luck. Bye.